and the beginning of the case, you notice that the judge has to handwrite, he has to take notes from very, very long submissions of very, very able lawyers. Is there something wrong even on a technical level of giving the magistrate the tools where other jurisdictions he would not have to physically write every word?
Yeah, because it's a very difficult process for magistrate actually. You may find one witness in the witness box for days, if not weeks, speaking to the court in terms of giving evidence the whole day, running to the whole week and 2 weeks and 3 weeks, and sometimes even a month. And it's a very, very tiring job. And recording the evidence accurately and almost in the words spoken by the witness is not easy. And therefore, probably we need to give the courts a better environment, better tools, better systems of recording, like in Parliament. Even in the county assemblies, we now have the Hansard. I think we can have better technology, use of technology.
Because, Jim,
because
in Parliament, I say this because the trial magistrate, the trial judge, are the primary takers of the pleadings, of the submissions. And even appeal will rely on that record. Is it possible for a man or woman of a case of this magnitude, single-handedly, to be able to, deal with the likes of the Orengos and the Kirkumis and, be able, a battery of top lawyers speaking on major matters of law?
Not easy. There was a time when probably stenographers were used, but I think now with the technology, I don't think we are well equipped to deal with cases of this magnitude.
For Kenyans, when you did the presidential petition, was it the same kind of...
Yeah, it was the same kind of recording. Each judge has to keep a record. But you see, that in a presidential election petition largely is on affidavits and pleadings and submissions which are given orally. And some of those submissions are given in advance. They are filed in advance. Now, if you go to the US, and we used to have a system like that in trials before the High Court, that, the record would have gone through a process of preliminary hearing before a magistrate, and by the time the case goes to the High Court for trial, then you have a pretty good sense of the case and how it moves, becomes much more
So Jim, is the problem with funding, or is it a problem of admin in terms of...
I don't think
when I was talking to Lady Justice Baraza on Point Blank, she said that when her and Mutunga took office, one of the things they were looking at was to modernize. In fact, IT and ICT was a critical part of modernizing the judiciary. Is this something ongoing? Is it dead in the water? The reform from an admin point of view.
I think it's an objective which has remained unfulfilled. And we need more than anything else funding and training.
But Help Kenya, you're an active lawyer.
Yes.
And the law, LSK, yourselves, is there no...
The problem is normally the attitude towards the judiciary. I think if we came to the conclusion that the judiciary plays a pivotal role, then in allocating resources to the judiciary, we would be more conscious.
I'm asking you this because if Kenyatta is watching you tonight, his job doesn't stop in giving support to Kinoti and Haji. Kenyatta would need, in my view, if his legacy is to be properly fulfilled, to go further and wonder what the judicial arm requires. Because obviously the test of the pudding will be in the judicial...
Yeah, I think at the beginning there was... bad blood, if you may like it, if I may put it that way, rather, between the judiciary and the executive, and also elements in Parliament which, were very disdainful of the judiciary. But democracies are normally judged by how the judicial system operates. The law enforcement agencies.
But Jim, this is point blank. So what I'm only asking, if Kenyatta is watching you, what support can he give as a practitioner.
Yes, and those,
in court.
And he's not just watching. When they had the corruption conference some 4 or 5 months ago, which were held, I think, at Bomas, these issues came up. In fact, Chief Justice Maraga attended. So these are critical matters to deal with. And you know, by the way, President Kenyatta has got only 3 years. And the number of cases which are now before the court, I doubt if many of them will be concluded before his term expires. And therefore, he needs to act very fast. And he may need to absorb more people into the judicial system.
Now, Jim, another matter in terms of political strategy I wanted us to deal with is about this idea of turning to state witness, where the prosecutors can do deals with certain witnesses or accused persons in order to get the real big fish, because you were talking here about grand corruption.
Yep.
Is it now a properly followed prosecutorial strategy to kind of, get a thief to catch a thief?
Yes, I think it's inbuilt in the criminal law, and more particularly, the penal code read as together with the criminal procedure code, where you can plea bargain. Now, plea bargaining, at least the way I understand the law as it is in Kenya, cannot result of a declaration of innocence. You could still plea bargain to a lesser offense or get out with a light sentence, a non-custodial sentence, or such terms as may be agreed between the defense and the prosecution with the approval of the court. But it is not meant, to kind of leave impunity unpunished.
Yeah, but Jim, I'm asking that because just looking at the accused persons now,